Welcome to today's episode of Connecticut Paid Leave Spotlight. I am Erin Choquette, the CEO of the Connecticut Paid Leave Authority. Today, we will discuss how to complete the employment verification form. This presentation is intended for Connecticut paid leave covered employers, but it may also be helpful to Connecticut workers who intend to file a claim for benefits and would like to better understand how we use this information. During this presentation, we will refer to the Employment Verification Form as the EVF. Today, we will review the purpose of the EVF and provide a section-by-section explanation of the form. Connecticut Paid Leave allows eligible workers to receive income replacement benefits when they need to take time away from work for qualifying reasons. The EVF provides us with information we need to calculate those benefits. Once a worker submits an application for paid leave benefits, they will receive an EVF that is pre-populated with their name and claim number. The worker needs to give this form to you, the employer, to complete. If a person works for more than one employer, each employer must complete the EVF because Connecticut Paid Leave looks at total wages and total hours worked from all covered employers when determining benefits. Let's review how to complete the EVF section by section. Section 1 relates to the applicant and is usually completed by the applicant, but it could also be completed by you, the employer. You should have the information necessary to complete Section 1 because you should be working with your employee to determine if they are eligible for job-protected leave under Connecticut FMLA, federal FMLA, or other state or federal laws. Even if you determine that the employee is not eligible for job-protected leave, you must still complete this form because Connecticut Paid Leave eligibility requirements differ from FMLA. If you did not know that your employee needed leave before they gave you this form, you are now on notice, and you will need to complete an assessment of their FMLA entitlements. But we also need you to complete this form within 10 days of receiving it, even if you have not yet finished your FMLA analysis. Section 2 relates to you, the employer. We ask you for your FEIN, or Federal Employer Identification Number, to help us distinguish between organizations with similar names. It also helps us verify the worker's wages. It is important for us to have a phone number and email of the employer representative completing this form. We use the email to notify you of the status of your employee's claim. We will accept a group email such as benefitgroup@employer.com. The statute that created the Connecticut Paid Leave Program specified that certain categories of employers may not be covered by the program. If they are not covered, their employees do not pay contributions into the Paid Leave Trust and cannot receive benefits. But sometimes those employees will still file a claim. If you receive an EVF and you are a non-covered employer, we need you to complete sections 1 and 2 of the form and check the box in section 2 that describes your organization. But you do not need to complete the rest of the form unless we provide you with specific instructions to the contrary. Sections 3 and 4 relate to wages and schedules. Section 3 is relatively easy to complete if your worker has a regular or fixed work schedule, such as Monday through Friday, Tuesday, Thursday, Saturday, 30 hours a week. If your worker has a variable or rotating schedule, we ask you to indicate the days they typically work. For example, if they work every other weekend, check box Saturday and Sunday because they could work both days. If they alternate between working Monday through Thursday one week and Wednesday through Sunday another, check all the boxes. For workers who have variable or rotating schedules, including workers who work overtime, we need to create an average schedule in order to administer the benefits. Please indicate the number of hours they worked in each of the 12 weeks before they went on leave, including any overtime worked. If the employee used paid time off during any of those 12 weeks, please add in those PTO hours as well. The Employment Verification Job Aid, found on the Application Document Checklist page of our website, offers additional guidance on completing this section. Section 4 provides space to note any time the employee would not be scheduled to work due to work-related closures, such as holidays, a midsummer shutdown, etc., as opposed to days the employee is out of work for their own personal reasons. Section 5 asks about other sources of income. Under Connecticut law, employees cannot receive Connecticut paid leave benefits if they are also receiving workers' compensation income replacement benefits, specifically temporary total disability, TTD, or permanent partial disability, PPD benefits. Therefore, at the top of Section 5, we ask if your employee is receiving any workers' comp income replacement benefits. If they are ineligible to receive Connecticut paid leave benefits during that period of time. If they are receiving medical-only benefits through workers' compensation, that is not a bar. If your employee has applied for workers' comp but has not yet been approved, the employee may receive Connecticut paid leave benefits, but we will notify them that they will have to repay those Connecticut paid leave benefits if they become approved for workers' compensation. Section 5 also asks about employer-provided income replacement benefits. Connecticut law says workers may receive income replacement benefits from their employer together with benefits from Connecticut paid leave, as long as the total amount does not exceed 100% of the employee's regularly earned wages. Income replacement benefits refer to employer-provided sources of income to the worker, such as sick leave, vacation time, paid time off, disability benefits through a group disability insurance policy, or group self-funded disability plan, or other such monetary benefits that you provide to your employees. Think about what policies and procedures you have in place. Do you offer PTO? If so, is it all in one bucket, or is there separate vacation and sick time? Do you require your employees to use their PTO when they are on leave, or is it up to the employee? Does it depend on the reason for leave? For example, are employees required to use sick time when they are on medical leave, but not required to use vacation time in that situation? Please remember that if your employee is taking leave under Connecticut FMLA, you cannot require them to exhaust all of their PTO, sick time, or vacation time in connection with the FMLA leave. You have to give them the option of reserving up to 2 weeks of such time to be used for other reasons. If you have a group short-term disability plan, what does it say? Does it require employees to exhaust other sources of benefits first? If you aren't sure, check with your insurance carrier or broker. Once you have refreshed yourself on the details of your policies, it will be easier for you to complete the EVF. Specifically in Section 5, you must select whether any employer-provided income replacement benefits will be paid to the employee during some or all of the leave. Check the first box if you will not pay your employee any income replacement benefits during any part of the leave. Check the second box if you will provide your employee with an amount equal to 100% of their regular wages for the entire time they will be on leave. If you check this box, we will have to deny the claim for benefits because of the law requiring that the employee cannot receive more than 100%. In that situation, the worker's bucket of up to 12 work weeks of Connecticut paid leave benefits remains untouched and available to them if they have another qualifying situation. Check the third box if you are providing your employee with an amount equal to 100% of their wages, but for only a portion of their leave. For example, if your employee needs to take 6 weeks of leave and will use their PTO for the first 2 weeks, check this box. We will also need you to tell us the day their PTO will stop so that we can start paying Connecticut paid leave benefits as of the next working day. Check the fourth box if you are providing your employee with an amount that is less than their regular wages for some or all of their leave. If and only if you check the fourth box, we will also need to know if your benefits are primary or secondary. The reason we ask about primary or secondary is because of the law which says Connecticut paid leave plus employer-provided benefits must be less than or equal to the employee's regular wages. Although this is a simple-sounding equation, it is complicated by the fact that Connecticut paid leave benefits are not actually based on the employee's current wages. Instead, they are based on an average determined by looking at the employee's total earnings from all covered employers earned in their highest 2 quarters in the first 4 of the 5 most recently completed calendar quarters. The easiest way to think about primary and secondary is to think about who will be responsible for adjusting the benefit amount to make sure that the combination of paid leave benefits plus employer-provided benefits does not exceed 100% of the wages. Primary means the amount the employer-provided benefits you pay will be the same regardless of whether your employee gets any money from Connecticut paid leave and regardless of the amount of that benefit. For example, if you pay your employees a flat rate of 70% of their wages when they are on leave with no alterations, then your benefits are primary. Secondary means your employer-provided benefits will be reduced or not paid at all, depending upon what the Connecticut paid leave benefit is. For example, if you have a group disability insurance policy that provides your employees with up to 60% of their wages, but will reduce that amount depending upon what other benefits the employee is eligible for, then your benefits are secondary. Or if you allow your employees to use PTO to top off the benefits Connecticut pays, then your benefits are secondary. If your benefits are secondary, Connecticut paid leave will pay the full amount of the benefits as determined by the statute which tells us how to calculate benefits, and it will be up to you to reduce the amount you pay if necessary. When the claim is approved, we will notify you and tell you the weekly benefit payment we will be paying so that you can make any necessary adjustments. If your benefits are primary, Connecticut paid leave will have to reduce the benefits we pay. Because Connecticut paid leave benefits are based on the worker's total earnings in the base period and not on their current regular wages, the only way we can be sure we are complying with the law is to calculate the benefit amount based on the statutory rules as if there were no employer-provided benefits, and then reduce the benefit amount by the percentage that the employer is paying. If you are paying 60% of the employee's current wages as the primary payer, we will pay 40% of the benefit amount we would otherwise have paid. We essentially turn the benefit payment into something like a reduced schedule leave. So in this example, when we pay 40% of the benefit amount, the worker is using up only 40% of that week of their entitlement. The worker receives less money per week, but they are drawing down on their weekly benefit entitlement more slowly. If you check the box that your benefits are primary, you need to tell us what percentage of your employees' gross wages you will be paying. We also need to know the duration of time that you will be paying this benefit. If your employee will be out on leave for 12 weeks and you will be paying your primary benefit for that entire time, indicate 12 weeks or put the actual calendar days on the duration line. If, on the other hand, you will pay your primary benefit for only 4 weeks, indicate that instead. If the amount of the benefit payment that you pay will change over time, there is room for you to indicate that. Section 5 is a section of the form that many employers will not have to complete. This section relates to 2 types of leave that, under FMLA regulations, require additional approvals from the employer. Specifically, when an employer allows bonding leave to be taken on an intermittent or reduced schedule, or when the employer and employee agree to taking qualifying exigency leave as a military family caregiver for a, quote, other approved reason. If either of these situations apply, you will know it because you've approved it for FMLA, and we simply need to know the frequency and duration of the leaves that you have approved. If neither of these 2 leaves apply to your worker, skip Section 6 entirely. Section 7 is the signature section. We need the form to be signed so that we know it was completed by an authorized employer representative. It can be a wet signature or a digital signature. While we prefer an actual human being's name to be listed here, we will accept the name of the employer and the department or unit that is responsible for completing the form. Once the form is complete, you may submit the form to Connecticut Paid Leave's Claims Administrator via email or fax using the addresses included on the form, or you may return the completed form to your worker to submit. For more information, please visit our website at connecticutpaidleave.org.